where is justice for the victims? Why all this love and compassion for somebody who, even if he didn't do it, he ain't never said justice for the victims? That's what a lot of people are saying. They saying, man, listen, besides, most jurors did want to convict Melly. They wanted to convict Melly of those two murders. So this is coming from a former juror. I said, this is coming from a former juror who said it was one lady who they believe was brought in to start pure chaos. And then we cannot forget during the pandemic, our courts down here in South Florida was closed down. Hell, as a matter of fact, the whole world was closed down during that COVID thing. And if there was ever any doubt in my mind whether or not did Melly commit the crime, when I saw this picture right here, I said, oh no, somebody was in that vehicle. Because if not, how in the hell this shell casing get in there? Make it make sense. It's not making any sense to me. And then, okay, all right, let's take that out the equation. Let's take all of that out the equation. What was this? What was the purpose of writing this? What was the purpose of having these notes? What was the purpose of his co-defendant worried about jurors and this and that? What was the purpose of that? Like, gotta use common sense. And then I ain't gonna even talk about Mariah. Yeah, Mariah, you was not court ordered to appear, but you still didn't appear. I believe even if she was court ordered, she would not have came anyways. Yeah, let's put this up. Like when I saw that picture, I was like, man, when I saw this picture right here, I said, well, who could have done it? Whoever was sitting back there, whoever was sitting back there. Let's play a little bit of this. Hopefully, it all goes through. Yeah, man, it is what it is. Melly made his bed. Facts.
Faced with a penalty of life in prison, they feared that that person would abscond or they would flee. Mr. Demmons knew he was going to be charged with 2 counts of first-degree murder. At 19, he could have ran, he could not did anything. He did the right thing, Judge, and he turned himself in. I believe February 13th, 2019. 6 years.
Okay, and before he really like said, okay, you know what? I'm going to turn myself in. He posted this video that was not shown to the jury.
With regards to that last video that counsel is taking issue with, this is the absolute last video or audio file that is on this phone before the defendant turns himself in. And he does use that term, however, I think in the totality of the circumstances, it is more probative than prejudicial.
We stipulate that he used the phone on that day.
My name is Melly, and I'm gonna turn myself in, but I'm in a suitcase because these privates are harassing me, and I have to get on a private jet, and I don't want them to see me.
So in terms of, it shows the defendant just prior to his arrest and booking, and showing that he was turning himself in, which was already been testimony about, that was brought in from the defense with regards to Deputy Maycock, who did the booking prints in this case.
We'll stipulate that he used the phone on that day to avoid the potential prejudice of him offending jurors on with a racial pejorative.
Play it again.
Sure.
Listen, everybody. This is Junior Fleet. My name is Melly, and I'm gonna turn myself in. But I'm in a suitcase because these rappers are harassing me. And I have to get on a private jet. And I don't want them to see me.
Even if you ain't want nobody to see you, that alone right there is weird. You could have had your goddamn attorney to come with you to turn yourself in. They would have made sure you would have been very, very, very discreet. I see it done all the time. My auntie had to turn herself in, even though she ain't no celebrity. But if she was, I mean, accommodations could be made.
Years of his birthdays in that jail. The last 3 years that he's spent in that jail, he has been deprived of basic human needs, basically.
Watch what the judge gonna say.
He's currently housed in a situation that's 23-1.
Counsel.
Okay.
The lawyers don't keep evidence. So if you want to present some evidence, I read that in your case, but there's nothing in front of me about what his current conditions are in jail. So
Okay,
that should be just something blank.
so the conditions in the jail aren't good. He's been there 6 years, Judge. The Constitution says everybody gets the presumption of innocence. 6 years. We're going now past 6 years. He has substantial ties to the community. His mom, his grandma, his sister, his brother, his friends, his grandpa. They're all here supporting him.
And she just in there popping away with that damn chewing gum. You heard that chewing gum say,
The special conditions are there, and that's what we get out of the different case law. That pre-judgment rape is one thing. You go to the second. Are there special conditions that we can put in place to protect those,
still popping that gum. Ooh, I hate to hear that.
to make sure there's no harm and the integrity of the judiciary? I don't have any evidence before you. We're precluded of putting my witness on. He has no risk of flight, though, Judge. I don't think there's anywhere in this world that Mr. Demons can go at this point without being known. There is no danger to the community. This was an insulated incident that he's being accused of. But again, I believe the special conditions that we put in place would protect the public from any risk of harm. They would also assure his presence at trial. And again, we would be protecting the integrity of the judiciary. And I believe we admit it, the state has not presented to us any reasons or any special conditions that would say that he should not be eligible for a bond. And I will also just point out that the whole purpose of bond is not to punish the defendant. It's to assure their presence at trial. That's the whole basis, is to make sure they're coming to court, make sure they're showing up to trial, and they're not absconding. I believe there is enough before this court that the court can safely rely that he's not a flight risk, he will be in court, that the community will be protected. Nothing further.
Yes, Judge, just responding to the points that were raised. Just so the court's aware, we have not litigated yet, but there is a pending motion to exclude the testimony of both Ms. Boutros and Ms. Bradley. It deals with a collateral matter, and we obviously believe it's not going to be relevant to trial. They keep raising the issue, or they repeatedly raise the issue, that Detective Moretti's sworn perjury, except there's been no finding of that, and there's no evidence of that, and actually the evidence tends to be the contrary. Judge Murphy found no Brady violation in regards to Ms. Bradley. There were no findings of Detective Moretti's testimony during the motions to suppress. And attached to the motion to exclude her testimony is the IA clearance letter for Detective Moretti, finding that he had done nothing wrong. So when they say that he suborned perjury, there's no evidence supporting that other than their argument and the testimony of Ms. Boutros, which they say now is going to go unchallenged, except that's also not correct. While there is currently a court order saying she's not subject to cross by the state still has the ability to impeach witnesses. So she still is going to be subject to the same impeachment that she faced during the motion to suppress.
Objection. I'm sorry, Judge, that's just
stating a fact is absolutely untrue. It's not performed. I don't know why I keep right.
I'm responding to their
It's
arguments.
How's your client's family members? I'm sure she's telling me the truth, but that's not for me either. I have no idea. So, I mean, I did 10,000 bond hearings in the regular division. Family members would testify. Here's our address. Here's our finances. Here's our ability to pay. You want to do anything? Go ahead.
I'm just responding, that's all. Sorry. In regards to the testimony of both Collins and Moretti, which is contained in the transcript, Brendan Collins testified as to the cell tower location information, which does put the defendant near the crime scene as well as the hospital, subsequently afterwards, as well as the following the path. What Detective Moretti testified to was the environmental data. As Ms. Liberty pointed out, the FBI will not rely upon that because they don't know how that is calculated. It does not mean, nonetheless, that Detective Moretti cannot testify to it because cell site location information does not require expert testimony. It can be subject to the same cross that he was in the first trial. I think that covers it as to the phase one arguments. As to phase two, if the court is going to consider exercising discretion, obviously there's two factors here. One is that the defendant charged with homicide. He's killed two people, so he's clearly proven himself. He is.
Look.
He's already established that he presents a danger to the community, but not only that, he intended to tamper with witnesses while in custody. It's actually the reason Mr. Henry is back in custody because he did have a bond and that bond was revoked. Had Mr. Devins been on bond, his bonds obviously would have been revoked and he'd be back in custody as well because there is probable cause that a new crime was committed. But to say that there's, and I'm not going to litigate the C4 motion, but to say there's no evidence is also not an accurate statement. There are videos, jail calls, kites that all were recovered that are part of the 23 case. So I don't think it's accurate to say that there's no evidence supporting the fact that he tampered or attempted to tamper with a witness. And finally, saying that there is nowhere that he can go that he's not known, that's not the concern. The concern is if he goes somewhere where he cannot be returned. As the court has repeatedly pointed out, Mr. Devins is charged with the death penalty. Many countries in the world will not extradite back to the United States if they are facing the death penalty here. So the risk of flight with him is actually greater because it is going to be much more difficult to recover him should he leave the jurisdiction.
May I respond, Judge?
Password.
So, as to your comment, in light of my client's popularity, we opted not to put somebody on to give you the address of where he'd be living at. We were going to proper, I would give that in camera as far as where he could live at. He would be residing with his sister and with his brother. I'll give you the address.
Yep, and I guess we was waiting yesterday to find out, at 3:30 with the judge, because he said court is recessed to 3:30, but we didn't find out. Now, so we're gonna have to wait to see if Melly is granted that bond that his record label has set out to put up to secure his freedom. I'm your host, Velvet, coming through for you on the Velvet is Balanced Energy channel. Wind up your Melly. Hey, man, there's a lot of people that want Melly free, but then you got the people who want him to stay where he's at. And I am up out of here. Yeah, Melly, they said you made your bed. You gotta lie in that thing now, bro. It's a hard bed. But damn, bro, you made it.